Well, what happens when the government asks companies to pay about $100,000 for certain H-1B petitions? And then a court says that the fee should not exist. Well, that's exactly where the H-1B battle has reached today. The US Court of Appeals for the First Circuit has rejected the federal government's emergency request to pause a lower court ruling that had vacated the $100,000 H-1B payment requirement. And this is significant because the government had wanted to keep collecting that money while its appeal continued. But the court said no. Well, the dispute goes back to the case known as the State of California versus Mullin. A Massachusetts federal district court had ruled that $100,000 payment requirement imposed on certain new H-1B consular petitions was an unlawful executive mandate. In simple words, the court questioned whether the executive branch had the legal authority to impose such a massive financial burden, and that without any clear authorization from Congress. In the meantime, the Department of Homeland Security challenged that whole decision. DHS asked the appeal court for an emergency stay. The government essentially wanted the fee collection to continue while the larger legal fight moved forward. But the First Circuit rejected the request. The court found that the government had not demonstrated a strong likelihood of succeeding on the merit. And yes, that brings us to the bigger constitutional question tonight. How far can the executive branch go when immigration policy comes with a lot of financial consequences? Well, the court's reasoning, as described in the resources, is that major financial burdens of this kind require clear congressional authorization under immigration law. The government had pointed to provisions including Section 212F and Section 215A. But the court did not accept those provisions as authority for creating a corporate entry charge of this scale. And yes, now comes another important development. Following the ruling, the Department of Homeland Security issued an update saying that although it strongly disagrees with the decision, well, it will comply with the court order. Now, for the H-1B workers, employers, and the wider tech industry, this is more than a courtroom technicality, because the H-1B system is already one of the most closely watched immigration pathways for skilled foreign workers. And yes, when the cost of hiring or transferring foreign talent suddenly moves to tens of thousands of dollars, companies have to rethink their decision. Should they hire? Should they transfer? Should they sponsor? Or should they move the role elsewhere? This is the real battle behind the headline. And for Indians in particular, every change in H-1B system, it can have consequences, and that too far beyond immigration paperwork.